Hello and welcome to this video on planning with the main residence. Unprecedented increases in house prices over the last decade mean that many older clients who do not hold substantial investments may nonetheless be facing a significant inheritance tax liability on death. Some of these clients may also be concerned about the potential impact of care costs on their inheritance that they plan to leave to their families and may be looking for ways in which to preserve the home's value. A lifetime gift of the home, either outright to children who live elsewhere or into a trust, is something that is often contemplated in these situations. However, it is unlikely to achieve the desired objectives and may, in fact, create more problems than it solves. For example, a gift to trust would constitute a chargeable lifetime transfer and result in an immediate liability to inheritance tax at the 20% lifetime rate if the property is valued at more than the nil rate band or bands of the property owners. An outright gift would be a potentially exempt transfer, so no lifetime liability to inheritance tax regardless of the size of the gift, but this could jeopardize the client's security of tenure, particularly in the event that the donee divorces or dies and the property passes outside of the family. Unless the client was willing and able to pay a market rent for continued occupation, the arrangement would also give rise to a gift with reservation. And if a market rent is paid, the rent, which may have already been taxed in the hands of the client, will be subject to further income tax of up to 45% in the hands of the new owner. Capital gains tax private residence relief could also be lost in respect of any future gain unless the owner continued to occupy the property under the terms of the trust of which he was a beneficiary, which, as we've seen, is not inheritance tax effective. The residence nil rate band could be lost as well and would not be available to offset against any failed gift, meaning that in some cases the inheritance tax position could end up being worse than what it would have been had no gift been made. And in addition to all of this, where the motivation for the arrangement is to avoid or reduce the charge for care, the gift could amount to deliberate deprivation, meaning that the objective will not be achieved. This will be a particular issue if the client is already envisaging that he or she will need care at the time the gift is made. So what's the solution for these clients? Sadly, other than life insurance written in trust to fund for the liability, which can provide a comparatively low-cost solution in some cases, subject of course to insurability, there is no single easy answer. There are, however, a number of ideas that clients can explore depending on their specific circumstances. The fundamental first step in any inheritance tax planning exercise designed to mitigate tax on the main residence will be to ensure that maximum benefit will be obtained from the resident nil rate bands. This can be achieved by reviewing and, where necessary, updating wills to make certain that the home passes, or at least is deemed to pass, outright to children or grandchildren on second death. This would be especially important if wills have not been updated since before April 2017, as any contingencies or flexibility that might have seemed like a good idea pre-2017 could compromise inheritance tax efficiency now. If the home or the estate, including the home, is worth more than $2 million, married couples should consider leaving a first death gift to children or to a trust to minimise the amount passing to the surviving spouse. This will help keep the estate on second death down below the all-important $2 million threshold for residence nil rate band, potentially saving up to $140,000 in inheritance tax. In cases where the home is the only significant asset in the estate, the will could make provision for the first death gift to be satisfied by an IOU. Clients with surplus income could kill two birds with one stone by making a gift of the home to children and then paying a commercial rent for their continued occupation. This would stop the surplus income from accumulating in the client's estates and adding to their inheritance tax problem, and would not jeopardise availability of the residence nil rate band as long as the clients had other assets up to the value of £350,000 that they could leave to their children on their death. Clients who share occupation with adult children could consider gifting a share of the home to the occupying child. This would not be a gift with reservation, create any CGT issues, or cause the residence nil rate band to be lost, provided that the retained share was worth at least £350,000. And in this case, there wouldn't be no requirement for either party to pay a market rent to the other party. Finally, for married clients whose main priority is protecting the value of the home against potential care costs, a more robust and inheritance tax efficient alternative to transferring the property to a trust during lifetime might be to rearrange affairs so that a half share of the family home is left on first death to a life interest trust for surviving spouse and thereafter to children outright. The trust would be contained in the will, meaning that there is no chargeable transfer during lifetime and also no question of deliberate deprivation. Further, following first death, the deceased share of the home will be comprised in a trust that enables continued occupation by the survivor without the property share forming part of the survivor's estate for the purposes of any means assessment that may have to be carried out in the future. There is also an argument that the arrangement reduces the survivor's personally owned half share to negligible value due to lack of a potential market for an interest in a property that is part owned and available for occupation by someone else. Provided that the property share held in the trust passes outright to children on death of the life tenant, there will be no adverse impact on the residence nil rate band either. I hope you've enjoyed this video. For more detail on these ideas, please visit TechLink and search for some of the key terms. Thank you.